Hello everyone, welcome to the video. Today we are going to be looking at intoxication. So let's begin. To determine whether D has a defense, we first need to establish the kind of intoxication he is under. And there are two types of intoxication: voluntary intoxication and involuntary intoxication. Voluntary intoxication is when the defendant has chosen to take the intoxicating substance, whereas involuntary intoxication is when the defendant did not know he was taking an intoxicating substance. Please note that in certain situations, this could be the defendant taking drugs willingly, but the drugs have a different effect than expected. Next, we must determine what type of crime the defendant is alleged to have committed: a crime of basic intent or specific intent. A basic intent offence is where the mens rea for the crime includes recklessness in its definition, usually alongside intention, for example assault, whereas a specific intent crime requires intention only in its mens rea, for example murder. Now, let's take a look at voluntary intoxication. Where the defendant is voluntarily intoxicated, he will have a defence to a specific intent crime, provided he is so intoxicated that he has not formed the mens rea for the offence. For example, in Sheehan and Moore, two defendants killed a homeless person by setting him on fire, but they were not guilty of murder as they were so drunk they didn't form an intention to kill or cause grievous bodily harm. Where the offence charge is of basic intent, voluntary intoxication cannot be a defence. The defendant is seen as reckless in becoming intoxicated, so has the mens rea for the basic intent offence. For example, in the case of Majewski, the defendant took a combination of alcohol and drugs over 2 days. While intoxicated, he became violent and attacked several people, including police officers. He was charged with various offences, including ABH, arising from this spree of intoxicated violence, and his voluntary intoxication was not a defence to these basic intent crimes. Okay, let's now look at involuntary intoxication, where the defendant did not form the necessary mens rea due to his involuntary intoxication. He will not be guilty of a specific intent offence, or a basic intent offence. For example, in Hardy, the defendant was depressed and took some Valium, a drug meant to calm people down, not knowing they would make his behaviour unpredictable, thus rendering him involuntarily intoxicated. He then set fire to a wardrobe. His conviction for criminal damage was quashed as he lacked the necessary mens rea due to his intoxication. Finally, involuntary intoxication will not provide a defence if the defendant had the necessary mens rea at the time of the offence, and the case for this is Kingston. So that is all for today. If you found this video useful, leave a like and subscribe for more A-level law content. If you want more law-related videos, check out my TikTok as seen on screen. Thank you for watching.